Good afternoon, everybody. This is David Conaway with Shumaker. Welcome to the ACC Manufacturing Affinity Group event that Shumaker is sponsoring. The topic today is COVID-19 impact for manufacturing companies, strategies to flatten the curve with customers and the supply chain. So appreciate there are a number of people who have helped pull this off and present this to the group today. I'd like to thank Cheryl Elgin, my assistant, for helping put together the PowerPoint. Kelly Grosso and our entire marketing team for facilitating it and working with the ACC. Our IT team, that's a new function of the webinar culture, is we need to involve our IT team. And thanks to Kathleen and Jane and Misty from the ACC for all their assistance in working with our group. And most of all, thank all of you for attending today. I appreciate that very much. We saw a sign-up sheet that indicated something like 83 participants, which I think may be the largest attendance for a manufacturing affinity event that I remember. Usually we're at a brewery or a hemp farm or other locations, but today will be virtual, and that's just the nature of the beast right now. I miss seeing everyone in person. And the personal interaction. So I thought I'd start by trying to personalize this just a little bit and share with you sort of my COVID-19 experience. From a work perspective, it's been, well, quite busy, but I've been able to come into the office virtually every day, as has my team. Our office downtown Charlotte pretty much cleared out. And so driving in, the parking deck, and the office have been actually kind of pleasant places to be and very safe from a social distancing point of view. So in addition to that, not traveling, which is part of my my mode of operation generally, since I've not been doing any of that, my garden has gotten a lot more attention. The arugula is thriving. My son, who graduated from Keenan Flagler business school in May, stayed in UNC. He's now transitioned to Charlotte, where he's going to start a job. My daughter came at spring break when everything hit. She has stayed in Charlotte. She finished her third year of law school and exams through Zoom, and she's now studying for the bar exam through Zoom, which will be given in July. There was some question about that, but the impact on me has been I became my daughter's sous chef. And she has a particular requirement that I wash any of the greens that I serve her from my garden. So after day 63 of that, I screamed into the colander and strained my voice. So she said that was a dad joke, and I guess it is. But so what have I been doing as a lawyer? Well, I've been working on a lot of temporary concessions agreements. Been working on trying to grab security for the benefit of client suppliers with respect to their customers, doing some PPP loans and giving back the PPP money in some cases, working on forbearance agreements. There's been a very active cross-border activity representing U.S. companies with respect to the insolvency of companies in the last 30, 60 days in the UK, Ireland, France, and we also filed a Chapter 15 for a UK administrator to engage the automatic stay in the US. So it's been a very active cross-border time for us. And then, of course, we've been very heavily involved, knee-deep in a number of the big bankruptcies that have been filed in 2020, including Neiman Marcus, Borden Dairy, which is Neiman Marcus is in Texas, Borden Dairy is in Delaware, Dean Foods, which is one of the largest milk producers and suppliers, is in Texas. LSC Communications, which includes the old R.R. Donnelley in the Southern District of New York. McDermott International, also known as Chicago Bridge and Iron, or including Chicago Bridge and Iron, which they acquired, is in Texas. And Norpac, which is a big vegetable producer, big wholesaler of vegetables in Oregon. So we've been quite active and dispersed geographically quite significantly, though it's been remarkable how the bankruptcy courts throughout the country have pivoted to be able to handle full-blown hearings by telephone now. And while some courts, state and federal courts, have sort of shut down, bankruptcy courts have not. They have continued at breakneck speed, and I think they know what may be coming. So that's kind of what I've been doing. And just a couple housekeeping matters. I would like to, I know this sort of doesn't lend itself to a lot of interaction, but there is a question feature, and I encourage interaction as much as possible. So please feel free to ask questions during the presentation. I would really like to hear, frankly, from all of you or some of you, whoever wants to, about your experiences on the things I'm talking about, because it's a learning experience for me too. So I would really appreciate hearing your views and or your experiences, whether online today or after the fact by email or something. So so I encourage interactivity to the extent we can do that. And I will probably, I've done this presentation before. It goes a little longer than an hour, maybe 15 minutes longer than an hour, especially with questions and answers. So you're free to drop off at an hour. I understand you're going to only apply for an hour's worth of CLE, but if you want to hang on, I'll hang on, but there's no requirement to do that. So without further ado, let's jump in. The introduction, this PowerPoint was actually prepared at the end of March, beginning of April. And so I think everybody who's on this call probably has experienced the impact of COVID-19 on the market, on their businesses, on the supply chain, on their customer relationships, on their contracts, breaches of, I think you've probably experienced all those issues. So you can read the introduction at your leisure. But what companies should expect during this time? And I know many of you have already experienced this, but customers are going to request extension of credit terms. They're going to request acceleration of rebate payments, perhaps, or prebates. They might possibly request price concessions. Customers may also seek cancellation or suspension of purchase orders or contracts. And suppliers may, this is kind of an interesting dynamic because your companies are sort of in the middle. You have customers that you're selling to, but you're also having suppliers you're buying from. And so, you have the sort of the Damoclean sword to some extent about which way do you go, what position do you take? Because it might be the suppliers may be requesting of you some of the same things that you're requesting of your customers. So shortened payment terms, or cash before delivery, security for payment, additional financial information, and again, cancellation of purchase orders or contracts. I think it's sort of, everybody's pretty familiar now with what's an essential business and what's not. We have situations where we represent one of the largest personal tissue manufacturer, one of the largest in the country, and they are going great guns. And they're at max capacity and doing quite well, and their customers are paying, because if they don't, there's another customer who will pay. The paper and packaging industry is doing quite well, particularly in the food packaging. Corrugated boxes, those manufacturers are doing quite well. By contrast, we represent a tier 1 supplier based in Europe to the automotive industry, whose plants in Mexico are just shut down. And so they're shut down, just cold turkey. Same with the textiles. A lot of textiles run through Mexico and other Central and South American countries, and those are all shut down. So as a result of that, the textile companies are shut down. So it kind of depends on the industry you're in, but I think you know who they are now and know what industries you're in and how you're affected by that. Now, customers and suppliers will undoubtedly suffer some adverse impact on liquidity. They'll likely violate covenants with lenders. They will lose important customers or supplier relationships. And most importantly, and this is one that I think is important to emphasize, they may lose and likely will lose the support of their lenders or private equity sponsors. Different lenders and different PE sponsors, they respond to crises differently. I would have to say that as a uniform generalization, or as a generalization, they have been pretty aggressive by and large, particularly the private equity companies. I think another concept that I have seen is that customers and suppliers' financial statements and projections are just as my starting point is they're not reliable until someone proves to me differently. And the concept of EBITDA has changed to now the concept of EBITDAC, which is EBITDA plus COVID. And so I think that's a very interesting dynamic. In the Borden Dairy case, for example, Borden is one of the largest suppliers to the schools of milk. And so they filed in early January, and obviously all their 13-week budgets, their 26-week budgets that supported their DIP financing were all based on pre-COVID projections. And so they came out, and I think their CEO announced on Twitter or something maybe about a month ago that the COVID-19 would have a 20% negative delta on their revenue, which obviously makes a huge difference in their bankruptcy case for a company in an industry that's already struggling. So customers and suppliers, as a result of all this, restricted liquidity, less reliable financial projections, I think a lot more customers and suppliers are going to meet the insolvency requirement of the U.S. Bankruptcy Code. And what is that? You don't have to actually file. Insolvency occurs when liabilities exceed assets, the so-called balance sheet test, or when there's unreasonably small capital, or the cash flow test, or there's an inability to pay debts as they come due in the ordinary course of business. So I think you're obviously going to encounter a lot more companies that are just flat insolvent. Now, lenders and private equity sponsors of customers will likely restrict cash and liquidity. We've seen that, particularly in the Chapter 11 context. The various, as you know, there has been massive government stimulus initiatives throughout the world, including the U.S. And I think a lot of that will help postpone the insolvency, or at least a Chapter 11 filing, even though a company may be insolvent by the normal tests. So in these cases, I think customers and suppliers may linger in the so-called zone of insolvency without a formal declaration of insolvency or Chapter 11 filing. There are some customers and suppliers that will remain viable but challenged. Others will enter into the zone of insolvency, and some will file Chapter 11, and that's been happening. And of course, everybody's predicting that there's going to be a Chapter 11 tsunami over the next couple of years, starting pretty soon, starting now actually. The other point I'd like to emphasize is that in this context, when you have private equity sponsors in particular and lenders in the background, companies' normal business counterparts very likely have restricted or nominal decision-making authority. And so I think that's just important to know who's pulling the strings when you're having these discussions, who's pushing the buttons. So how can companies be proactive? One thing I think it's become abundantly clear is there's no panacea policy that you can just apply to all situations. It's a one size fits all for sure. Every customer, every supplier is different. They have different lenders and private equity sponsors behind them generally, and their industries are different. So it's just, you got to be very flexible, I think. In some industries, the first line of defense, like the ones that are going great guns, the personal tissue and the packaging industry, all of those suppliers, when they get temporary concessions requests, they're just saying no. And as a general rule, it's working. And so maybe the first line of defense is to just say no. If you have a need or a willingness to consider contract concessions, customers and suppliers should be willing. I think this is a time where normal asks you may need to go beyond the normal ask. And for me, one of the first and most important one is increased financial and operational transparency. If you're going to grant concessions as a result of COVID-19, you ought to just ask them, you need to give us more transparency, particularly since their financial statements may in fact be compromised or challenged, at least for now. Obviously having realistic discussions about the impact of COVID-19 on existing financials, their projections, and their future liquidity is really essential. I think disclosing loan covenant violations or restrictions on borrowing or liquidity restrictions imposed by the lenders and the private equity sponsors, I think that's a fair ask now. I think that's something that should be on the table. And also providing security is now a fair discussion point. I've always maintained that when there is a supplier that is a dominant and truly essential supplier to a company, then the supplier and the lender or the private equity sponsor are really co-venturers. And so, because as a practical matter, the sale of goods that you make to a customer creates the inventory and ARs that are the collateral that the lenders are willing to lend against. And so I think there's a dynamic there, and this is the time where I think you could exercise your stature as a dominant creditor to in fact try to negotiate some sort of security, which is going to involve the lender, because they obviously are going to have a lien on all assets. So what are the legal rights and issues? And so obviously you want to exercise legal rights judiciously, and where you can push back and how you can, and we'll talk about that a little bit more in a second. I think I've read more articles on force majeure in the last 60 days than I probably have seen in my entire career, frankly. It's just been amazing. There's Lexology and JD Supra. Every day there's probably 10 new articles that are posted about force majeure. But what I'd like to suggest to you is that Article 2 remedies actually have a much lower bar to access. And I'll talk a little bit more about force majeure a little bit later, but I start with the premise that force majeure is very narrowly construed by courts generally. For example, in the 2008 financial crisis, as a general rule, force majeure did not allow parties to get out of contracts. And so they're very narrowly, broad force majeure clauses very often just don't cut it. But the bar is much lower for some Article 2 remedies. For example, Uniform Commercial Code Section 2-609. Obviously, this relates only to the sale of goods, but it basically is the provision that allows a seller of goods who has reasonable grounds for insecurity about the customer's ability to perform to demand assurances of performance within a reasonable time not to exceed 30 days. And pending getting those assurances, the seller can stop shipping and stop extending credit terms, or one or both of those, frankly. Usually, we would always suggest to clients, cash before delivery is probably the best. You can still get goods out the door, which is in your best interest, but obviously not accept any credit risk as a result of that. So that's what this allows you to do. If nothing else, it's proven to be an effective tool to promote quick communication with the customer, and basically gives an opportunity to sort of pause in performance to mitigate your risk, or think about it, or evaluate it at least. And I think this is a time when reasonable grounds for insecurity are not going to be hard to prove. And they usually aren't. The bar for that, by the way, is fairly low generally, but with COVID-19, I think it's going to be even easier. And just to make one last point, this is a remedy that does not require default. They can be current in their payments to the supplier. Similarly, UCC 2-702, which I call cash before delivery upon insolvency. So basically, if you learn of a customer's insolvency, you're permitted a supplier can sell goods only on a cash before delivery basis, regardless of a contract that provides for credit terms. And Chapter 11 is not required to establish, a filing of Chapter 11 is not required to establish insolvency. It's a facts and circumstances test, like I mentioned before. So that's a very powerful remedy. And I think many companies, I think proving insolvency right now may be a little easier than it was, but you do have to have a basis for it. Reclamation, I'm not going to spend much time on that. I mean, reclamation, the courts are pretty clear. The reclamation rights are junior to the rights of lenders who have prior perfected liens on inventory. So the reclamation right has really been reduced to a often not available right. So I'm not going to spend any more time on it. Stoppage of delivery. Stoppage of delivery, again, if a customer is in if you learn of their insolvency, then you can stop goods that are in transit. But more importantly, or a point that I want to add, is that you can also stop delivery of goods in the possession of a bailee. So if you have a situation where there are goods in a warehouse, for example, particularly if you control it, then you can just keep them in the warehouse and insist on cash before delivery. So I think that's important too. To give you sort of a case example, we had actually it was an ongoing matter, and we're right in the middle of it, but we're involved in representing a U.S. company with respect to a customer who is now in administration in the UK. And administration is sort of their version of Chapter 11. It's very different, but it's similar. It's an insolvency proceeding, so to speak. And in that situation, what happened is they filed a notice of intent to go into administration, which gives them a 10-day moratorium, which can be extended for another 10 days. And they did that. So we knew that's a declaration of insolvency. So we knew they were insolvent. But we had a contract that said when the goods in the warehouse, when the customer pays the VAT, then title transfers. So we got a little worried about that we might be compelled to ship goods for which we knew we would not receive payment because the company was insolvent and had no funds and had no support of their lenders. So I told the client simply, do not ship the goods without cash unless a court orders you to do that, because you'll never get paid. And so we started looking at the documentation, and lo and behold, the client's terms of sale provided that Delaware law control, and we believe an English court will enforce that choice of law provision. A court in Hong Kong might not, but a court in Mexico might not, but a court in the UK would. And so we were able to roll out all these UCC provisions that basically made title passing irrelevant. And so we just used we didn't use reclamation, but we hit them with a 2-609, 2-702, and 2-705 notice, and just said, pound sand, when we get cash, we'll deliver those goods. So it'll be interesting to see how that pans out, but I think we're on pretty solid ground. So after recognizing the need for a flexible approach, there's some things that you could consider in these contract discussions. Again, one is just say no. Ongoing financial transparency as a condition of discussions. A couple of oldies but goodies. Interest upon default and payment of attorney's fees. Those just change the incentives. If they know that they're going to have to pony up on interest and pay your attorney's fees if you come after them, then that is some incentive to make sure you get paid. Another concept is, what we have seen is a lot of companies are providing various forms of rebates and sales incentives to gain a competitive advantage in the marketplace. And so this may be a time when these concessions, they ask for, we got an account receivable balance, we don't want to pay it for 60 or 90 days. Well, maybe you could eliminate or reduce or suspend rebates or sales incentives. Maybe even go ahead and set them off so that you can clean up the AR balance to some extent, and that might be a good way to resolve that. Maybe for some customers that are viable, you might ask for commitments for additional business. This may be an opportunity to, we'll support you, but we want to get a greater share of your business. Also, waiver of claim or indemnification for all losses. So arising from the concessions. And what I'm thinking about here is that, we'll talk a little bit more about this later, but if you grant temporary payment concessions, query whether or not that alters your future ordinary course of business defense in a preference context. And on its face, the answer would be yes, because the court decisions basically say anytime you alter or change the pattern of payment during the preference period from what it was historically, that by definition is you lose your ordinary course of business defense. So maybe you get an indemnification for losses arising from the concessions, which could include additional preference liability. Not going to be worth anything if it comes from the company, but maybe get creative and get it from a guarantor, a principal, and maybe that would have some value. Now, just to comment on this concept of COVID-19 preferences, you just heard what I said about the fact that it could impact your ordinary course of business defense. But I'd like to suggest and hope that this gets some traction in a couple years when these kinds of preference claims and defenses are going to be come to the forefront. I'd like to posit that judges, generally speaking, I think, have a distaste for preference actions. Now, they can't just ignore them because the statute does exist, but I think they really don't like the cottage industry that's developed, the fact that usually the benefit from the recoveries does not go to the creditors themselves in any meaningful fashion. And so courts, and you can see that in some of the opinions on ordinary course of business, and you can see that virtually no cases ever get tried. So no one wants to go to court. The plaintiffs in these preference actions don't want to go to court for a reason. And I have to believe that there'll be some accommodation made by bankruptcy courts when they're looking at COVID-19 concessions. And that's why I think it's important to have an agreement about this, which I'm going to talk about a little bit more in a second. But I query whether COVID-19 payments will be deemed to be ordinary during COVID-19. So that's just an interesting thought. Some drafting tips. I think any changes to terms or the contracts should be memorialized in a temporary concessions addendum or agreement and not as an amendment to the existing contracts. I also would recommend that concessions should automatically expire on a date certain, subject to extension if that's warranted, but they should have a deadline that when it happens, it's over. I think also, and this is very important, particularly for the preference concept I was talking about, the addendum should expressly recite the customer has requested a concession directly as a result of the impact of COVID-19 on its business and its inability to pay, and the company has agreed to that request or that concession according with the terms of the temporary concessions agreement. There should be strict compliance with the revised payment terms, which should automatically revert to the original terms if there's a default for even a nanosecond. In some of the hurricanes, Katrina and Sandy, these hell or high water clauses became useful, which requires performance going forward regardless of any future adverse circumstances for any of the extended terms granted. So they can't, double dip, so to speak. So I think that's an important thing to consider. Supply chain rescue. My sense is most of you have probably gotten your arms around your supply chain. It may not be, ideal. You may have problems in the supply chain, but you at least have identified who your suppliers are, which ones are at risk or are gone or whatever, and what you need to do to stabilize your supply chain. I think that the point I really wanted to make is that there'll probably be certain situations where companies may have to provide financial accommodations to critical suppliers in the form of prepayments, early payment. But I can see companies needing to get pretty creative about supporting their very critical suppliers, maybe even to the point of some sort of accommodation agreements or acquisitions. or consolidation in the industry with competitors. So I think a lot created new opportunities, I think, and new challenges in the supply chain. Let's talk about customers in the zone of insolvency. So as I mentioned earlier, the zone of insolvency is that period of time when a customer's insolvent. You can smell it. You may not be able to prove it, but you know it. The customers are in the zone of insolvency. They haven't filed yet. They're going to file. Sometimes it becomes public, so you can see news reports. And I think everybody in the world knew that JCPenney's and Macy's and Neiman Marcus were probably insolvent, but they hadn't filed yet because they were getting their papers together to file their Chapter 11 case. In this context, in this zone of insolvency, the most prudent action is likely to reduce the accounts receivable balance as aggressively as you possibly can, because I think we all realize that general unsecured claims in a Chapter 11 case have zero value. Now, I'll talk a little bit about those that are delivered within the 20 days prior, and there's a special treatment for that. But generally speaking, reducing the accounts receivable balance as aggressively as possible is prudent to minimize risk. Now, what this requires is a change to cash before delivery or a reduction in terms, which can be accomplished by utilizing 2-609 and 2-702 that I discussed above. Now, I've already talked about the adverse impact that might have on vendor defenses, and specifically the ordinary course of business defense. But here I'd like to emphasize that vendors have 3 defenses to a preference claim. Two that are most often used are subsequent new value. I got a payment, but as soon as I got the payment, I ship more goods. And that's a dollar for dollar credit. It's very objective, very easy to prove. There's really no disputes about those generally. And then the second one is the ordinary course of business defense, is what we're talking about. So keep in mind that if you reduce and change terms, you're altering one of your defenses, but not the other. It really has no impact on the subsequent new value defense. So, and we've always told clients, don't plan your business based on a potential preference claim. Plan it on doing what's best for the business, getting cash in the door, and worry about the preference later. Because generally speaking, they're defendable and they can be settled, and so they, you shouldn't plan around a preference, in my opinion. Okay, force majeure and impracticability of performance. I'm not going to spend a lot of time on this because my guess is all of you, like me, have read a lot about force majeure. A couple points, again, the very broad existing force majeure contracts, I think we're going to have trouble with. What we're seeing now is clients are receiving new purchase orders that have force majeure clauses that are very narrow. They're better drafted than they were, and they cover things like pandemics and the impact of pandemics and government orders, things like that. So I think that looking at those going forward is going to be a little different, because I think people have pivoted and made those a little bit more important. And same thing, UCCs, their impracticability of performance is a very similar concept of force majeure. It, like force majeure, has a very high bar for parties that are seeking relief in performance. Again, during the avian flu, it was found to be, market conditions, the major shift in market conditions was sufficient. Financial crisis generally was not. So now let's move on and talk about after a customer is no longer in the zone of insolvency, they're actually in Chapter 11. And I unfortunately think you're going to see a fair amount of this in 2020, 2021, and probably 2022. But obviously, selling goods or selling services to a Chapter 11 is a very high credit risk. Analysis of which goes far beyond the normal credit risk analysis of looking at a balance sheet and income statement, because there are many first day motions most significantly are the debtor in possession financing or a prepackaged or expedited Section 363 sale. Plans of reorganization are somewhat few and far between these days, but these first day motions really materially limit vendors' rights and the ability to be paid on the very first day of the case. And so it's very important for vendors, if you have a significant position with a customer who has filed, to review and understand those and possibly object to first day motions. We've been doing a lot of that in the cases I mentioned earlier. Now, to give you an example, in the LSC Communications case, their 13-week budget, and keep in mind that LSC Communications is a $2.6 billion company. Their 13-week budget showed liquidity drop to $10 million within during the 13-week, I think it was week 10 of the 13-week budget. Well, $10 million liquidity for a $2.6 billion company is razor thin as you can get. And so clearly the credit risk or their ability to continue paying in the ordinary course is highly challenged. And that was before professional fees. So you got to look, whenever I look at these things, the first thing I do is look at the DIP financing facility, and there's always a one-page, that's all it is, a one-page 13-week budget attached to the motion for DIP financing. The other thing I look at is the milestones that are in the DIP facility and also any sale motion, but they're always in the DIP facility. And I remember in the it was one of the big retail cases a couple years ago. I can't remember which one it was right now, but they were going out telling the suppliers to keep supplying, keep supplying, keep supplying. We're going to pay you, we're going to pay you, we're going to reorganize, we're not going to sell. But when you looked at the milestones in the DIP, what they said was you have to have a motion to approve a Section 363 sale within 60 days. You have to have a bidder, biddings has to concluded within 120 days. There has to, so they had all the sale procedures lined up, which made it very clear they were selling. They weren't reorganizing. So, and the rhetoric that you get from the representatives of the company is quite the contrary, simply because the lenders have said, while we're selling, while we're getting this thing postured up to sell, go borrow from your vendors, because we don't want to loan any more than we have to. So I think that's very important to analyze the credit risk when a customer files bankruptcy. It's a very unique and different analysis. Now, administrative expense priority claim. So doing business with a Chapter 11 debtor gives you, goods or services provided post-petition are granted an administrative expense priority claim. So that's a good thing. I'm going to come back to that in a second. But to qualify for administrative expense priority, two things have to happen. One is the post-petition shipments must arise under a post-petition contract, and the goods or services must be delivered post-petition. Very often what we see is there are pre-petition purchase orders that will be delivered post-petition. So what do you do about that? In many cases, for example, LSC, the debtors went and got an order of the court that basically addressed this very situation and said, when this circumstance arises, creditors who ship goods on pre-petition purchase orders will be deemed to have an administrative expense priority claim. But a lot of cases, they don't do that. And so that's a problem. And you need, what the typical remedy then is to, unfortunately, cancel the pre-petition, have them cancel the pre-petition purchase orders and reissue them post-petition, which is a pain and to be avoided if you can, but sometimes you just can't, particularly if it's a material potential exposure. Because if you don't have that situation, then what happens is sales to them post-petition or deliveries to them post-petition can be undone later. They can be clawed back as unauthorized post-petition transfers when the debtor paid you money for those goods post-petition. So another notion is that when lenders have liens on all assets and proceeds, the cash that's generated from the lender's collateral, ARs, when the ARs are collected, is considered cash collateral. And the bankruptcy code basically says a debtor may not use its cash unless there's a court order approving DIP financing or a use of cash collateral. And the cash collateral requirement is the lender either consents to the use of cash collateral or the court orders the use of cash collateral over the objection of the lender. And there was a scary case that occurred about 5 years ago, Marathon Oil, where a vendor was paid about $1 million cash before delivery post petition. So they thought they were safe. And a couple years later, that payment was disgorged by the estate from that vendor because the debtor, there was no DIP financing, and the debtor never got permission to use cash collateral. So, and of course, at the end of in those kind of cases, you can probably sense that if you got a situation where a lender's not providing DIP financing and not allowing use of cash collateral, chances are the case is really bad. And so the lender funded the estate to go after the vendor to recover that $1 million to shore up its shortfall in its lending. So that's very important. Now let me talk about administrative insolvency. Administrative expense priority status is great. And the traditional wisdom is administrative expense priority claims generally get paid. And that's because the pecking order of payment in the bankruptcy code is quite clear. You know, consensual secured creditors come first, but after that, the cost of administration comes second. And that's where professional fees lie, and those tend to get paid. And then it kind of comes down, taxes, employee benefits. But the very bottom are general unsecured claims, and then there's equity interest even below that. So if a company, and this has become quite a question in a lot of cases, and perhaps even most cases recently, there's always the prospect of administrative insolvency, because if the values of the assets are not sufficient to pay off the lender's debt, then the case is administratively insolvent. The other thing to point out is that in the DIP financing motions, as adequate protection for the lenders loaning additional money, lenders always obtain what's called a super priority administrative claim over all other administrative claims. So if the lender is undersecured, all of its unsecured claim would come ahead. So this is why it's so important to look at these issues before doing business with a Chapter 11 debtor. We in connection with LSC and Borden, we advise clients do not ship goods except on a cash before delivery basis. There's just too much risk here, and the market has reacted the same way. So now, if you have no sales agreement and you're just doing business on an invoice or purchase order basis, there is no requirement that the vendor provide to even sell goods or to extend credit terms. Now, if you have an executory contract, a sales agreement, the rules are a little different. And so I think it's worth walking through those a little bit, because a lot of you probably do business on a supply agreement basis. So an executory contract is simply a bankruptcy code term given to any contract between a debtor and a non-debtor where both parties have a material performance obligation. I always give the example that a promissory note is not an executory contract since the holder has no performance obligation. A supply contract, sales agreement, that is always an executory contract. So the rules, and I'm sure most of you who've experienced Chapter 11 cases know this, the debtor, part of the fundamental principle of a Chapter 11 case, debtors have really an unfettered right to decide whether they want to assume or reject an executory contract or lease. If they reject the contract, the non-debtor party receives a general unsecured claim for the damages that arise from the breach. General unsecured claims, as I mentioned earlier, rarely receive any value whatsoever, or if they do, it's illusory. So this is why debtors, they escape the contract with virtually no cost. And this is why you see a lot of, particularly in the retail industry, debtors utilize Chapter 11 because they can reject leases quite easily and cheaply. Now, by contrast, if the debtor assumes a contract, the Bankruptcy Code requires them to cure. And cure basically means paying pre-petition arrearages or pre-petition accounts receivable balances. And so it can be a path to payment for vendors, an assumed contract. So that's, it's a possibility there, but that's the debtor's decision. And there's not a lot creditors can do really to impact that decision. And by the way, they can only assume or reject. If they assume they can't assume and negotiate, they can assume it as is. And they can assume it and assign it as well. And that's in the 363 context is when that happens. Now, what's important is that the Bankruptcy Code requires a non-debtor party to an executory contract to continue to perform its obligations under the contract, pending the debtor's decision to assume or reject, and provided the debtor is, in fact, in performing its side of the deal. Now, so what that means is, okay, let's say you looked at all the credit risk I talked about earlier, and you decide that, wow, I don't want to sell this customer anything because their 13-week budget tells me they may be out of cash in 8 weeks. So I'm not going to, if I could go into another $1 million, and that would be very difficult to explain to the management team. So if this code requirement says you have to continue performing, well, your performance obligation under a contract is twofold: ship goods, extend credit terms. So that's a problem. And so we get into a lot of situations, and we had it with Borden. And of course, it's a lot of brinksmanship. We filed motions and had, motions to compel filed against us. But basically, our position is the obligation to continue to perform is subject to a seller's Article 2 rights, including 2-609 and 2-702. And we actually exercise this often, but most recently in the Borden case, client had a contract and we just assessed the risk as too great to extend them any credit. So we basically said, hey, we'll continue to sell you cash before delivery, but we're not performing our contract that requires us to extend terms. And we ultimately prevailed on that, but that's an important thing to remember. Now, I'm sure many of you have heard about the critical vendor remedy, and I'll talk about that a little bit more in a second. But a supply agreement that requires a supplier to continue shipping and continue extending credit terms, let's just assume for the moment that I'm correct, and that what that really gets translated into is the supplier has a right, has an obligation to continue to ship but not extend terms. Then the leverage is somewhat compromised to become a critical vendor. And again, I'll talk about that in a minute. Chapter 11 claims and remedies. I'm sure everybody's who's been in a Chapter 11 case is familiar with the 20-day administrative claim for goods that were received by the debtor, not delivered, invoiced and delivered, but received by the debtor within 20 days prior to the bankruptcy, even though there creates a pre-petition claim, are given the same administrative expense priority status that I mentioned earlier. And so the same issues regarding administrative insolvency that I mentioned earlier would apply. Now, critical vendor. Critical vendor is a lot of creditors get paid that way, their pre-petition debt. And this generally works when there is a vendor who is doing business on a purchase order and invoice basis and not on an executory contract basis, because debtors always take the position that if you have an executory contract, you're obligated to ship, and therefore we don't have to treat you as a critical vendor. And so if you have a purchase order and invoice based relationship, the probability of being a critical vendor is higher. And critical vendor is really a debtor selected opportunity. Vendors can't file a motion to say I'm a critical vendor. The vendors can only do a couple things. They can withhold shipment or withhold credit terms. That's the leverage they have to be considered a critical vendor, and that's when you find out whether you are or not. In the Borden case, the debtor got approval to pay $50 million to a combined group of critical vendors and 503b9 claimants, and spent like 20 million of it. So they got the authority but not requirement, or not the direction by the court, to spend the money. And so they were, again, the lenders behind the scenes, the private equity companies behind the scenes were saying, don't spend a dime more than you have to. Go work your vendors and attempt to minimize cash that we have to fund. And so it's kind of a dance, and there's this problem because if you withhold performance, there have been cases where they've said a willful withholding of performance to compel payment of a pre-petition claim is a violation of the automatic stay. And so you got to be very careful about the discussions that occur. We always advise clients to only have those discussions by phone and don't put anything in writing. But how those are handled are very, very delicate discussions. You got to be careful because you want to create the environment. And so what we tell clients is something along the lines of, yeah, engage with your customer. Ask them, hey, you filed a critical vendor motion. We want to know if we're a critical vendor. Please tell us. We're evaluating what we're going to do, and don't ever say we're going to cut you off until you pay our pre-petition debt. There was a poor vendor in the Collins and Aikman bankruptcy a few years ago that sent a letter to the debtor saying, unless you pay my entire pre-petition balance, I'm not selling you another stitch of fabric or whatever it was. And that letter got slapped as a Exhibit A to a motion for sanctions. And so you got to be very, very careful. If you do get paid as a critical vendor, and we had this come up in the LSC case, the quid pro quo now in every critical vendor order is that the creditor has to provide customary trade terms, which usually say terms of sale and also credit lines. So in a lot of cases, I tell clients, and in LSC, one of our clients looked at it and said, look, if we ship goods to this company that is, probably administratively insolvent, we're going to go, our debt, our pre-petition debt was something like $750,000. And a good chunk of that was in the 20-day period, so we had an administrative claim for that. If we had given them customary trade terms during the course of the bankruptcy, our exposure would have been $1 million. So our client politely declined the critical vendor status because it was just not a risk worth taking. So that's the calculus that you have to do in connection with critical vendor payments, but it's important that you do that. Set off and recoupment. Again, this is something we see a lot these days simply because companies seem to be providing all sorts of sales incentives and rebates that gives an opportunity to exercise the remedy of set off of what you owe them against what they owe you. And it's a very great remedy. The bankruptcy code says that a creditor has really a secured claim to the extent of the value of the set off. So, they owe you 100, you owe them 50, you have a secured claim for 50 according to the bankruptcy code. And that's dollar for dollar. So that's a good outcome. Basically 100 cents on the dollar for that portion of your claim. In bankruptcy code doesn't actually create a right of set off or recoupment. It recognizes them. It recognizes the right of set off. And they impose a couple additional requirements. One is they have to be the mutuality requirement, which means that the debts must be owed to and from precisely the same legal entities. No triangular set offs. Okay, outside of bankruptcy, not in bankruptcy. And they do not set off. It does not have to arise out of the same transaction. Recoupment, it does. Now, also, a lot of times we get asked, we think they're going to file, should we go ahead and exercise our set off remedy? And the answer is, generally speaking, no. The rules, because the set off rules in the bankruptcy code have some fairly complex rules regarding a potential preference for an improvement of position if you exercise it during the 90-day period. Generally speaking, it's better to just wait till they file a motion for relief from stay, exercise the set-off remedy, which is fairly clear-cut. So I'm sure you've all had opportunities to sell claims. You know, that can be an effective way to monetize claims early, and you know, we always think it's a good thing to look into. It's just sort of a buyer or a seller beware in connection with the documentation, because the buyers are all New York-based hedge funds, and they're heavily lawyered documents, and they have a lot of gotchas in them. So just be careful with claim sales. Avoidance actions, given the hour, and I'm sure most of you are fairly familiar with preference actions, but I will call to your attention the Small Business Reorganization Act of 2019, which, you know, had some provisions about the, you know, small company reorganizations, but it also had a couple of amendments to the preference statutes that it applies to any cases, not just small businesses. But now it requires the debtor to exercise reasonable due diligence, taking into account the creditor's defenses, and that's very important. And also for claims 25,000 or less, it used to be, I think, 5,000. 25,000 or less, the Chapter 11 debtor must assert the claim in the creditor's jurisdiction, which will shut down claims for 25,000 or less. But the reasonable due diligence is very interesting, because what that means is debtors can no longer just do the shotgun approach of, you got $100,000 of payments in the 90-day period, boom, that's our demand. Now it's up to you to assert your defenses. It's now saying, okay, they have to exercise reasonable due diligence. They have to give you credit, in essence, for your subsequent new value. They have to look at your ordinary course. So I think that's a very important dynamic. And one of the questions I have is, look at this 25,000 or less. Does that apply to after they have done their due diligence to account for the creditor's defenses, or before? So is it 25,000 gross or net of reasonable due diligence? And I think that's a position. We've started putting that in answers now. That 25,000, if we look at it and think the liability is less, we do a motion to dismiss on jurisdictional and venue basis because of that. So I think that's something to consider as well. Fraudulent transfers. Let me finish up with, and then I'll open up to questions and answers. A novel development in Chapter 11 cases, which is the suspension of the Chapter 11 proceeding. And one of the first case that's been discussed about this is Modell Sporting Goods, which filed bankruptcy, I believe it was in New Jersey. And they were going to close 153 of its stores through controlled liquidation sales. And so what happened is COVID-19 hit, and they filed a motion on March 11th under Section 305 of the Bankruptcy Code to suspend the Chapter 11 proceeding. And the concept was that if we do a liquidation sale now, well, we can't, because our stores are closed. People can't come into the stores. We'll be hurt. The lenders will be hurt. Everybody will be hurt. And so they went in and said, under 305, which allows for the court to either dismiss a bankruptcy case or to suspend the Chapter 11 proceedings. This is not one that has been used very much, if at all, in the past. I'm sure it's been used, but I have not ever seen this used until now. So the bankruptcy court agreed and said, we're going to suspend it through April 30th. It's been suspended again, or that suspension has been extended. And so I think that there will be, and there's another, Pier 1 did that, but then they recently just said, forget it, we're liquidating, we don't care. Another company, what was it? Craftworks, which is rock bottom brewery, basically a brewery restaurant. They did the same thing. So what mainly I've seen it in the retail context, have not seen it in the manufacturing context, but I really think it would be appropriate for that. For example, we were advising a company regarding, the impact on their business of the shutdowns in Mexico. And we knew that was going to be temporary. So I would think a suspension actually might work in a manufacturing context as well. So I think that's an interesting concept. But this is a kind of a cutting edge concept created just because of COVID-19. And so I think we'll see a lot more about this. So I'm going to conclude with that. It's right at the hour. So I was actually a little bit more efficient than I anticipated I would be. But I will open it up to questions. And again, now, later would be fine. Any experiences you have and are willing to share either now or later, I would very much appreciate it, because I'm learning too. And I'd like to hear how you're dealing with some of these issues. So I'll stop and open it up for questions. I see one question that just says seller question mark. I'm not sure what that means. Maybe I missed that earlier. It was in the context of a. Well, I'm not seeing any questions. So I think we can, whoops, sorry about that. We can end. Let everybody go and go back to work. Good luck, everybody, with what you're dealing with. Again, appreciate you attending, and stay safe and be well. Thank you.